Hello, Attorney Richard Winblad here, today talking to you about transfer on death deeds. What are they, and how do they work? Perhaps this illustration will work best. We've got Joe here. He owns some interest in real property. Now this can include things like houses, farmland, even mineral interests such as oil and gas. He has a relative. Actually, he could have several relatives he wants to leave property to, but for simplicity's sake, I'm just going to deal with one individual. He could make this a gift while he's alive to this individual, but his idea is to have it passed to him after he dies. He could also do a last will and testament or a trust, but he's also heard about a transfer on death deed, and he wants to learn a little bit more about that. Joe has several goals he wants to accomplish. First of all, when he's gone, he wants it to be easy for his relative to inherit it. He also wants to keep in control of his property. He wants to make sure that if he wants to sell the property, mortgage it, or do anything he wants with it, he doesn't have to get anybody's approval. Finally, he wants to make sure that his heirs' issues, like bankruptcy, divorce, judgment debts, or tax liens, won't cause problems for his ownership of the property while he's still alive. Joe decides he wants to go with the transfer on death deed approach. It's a pretty simple process. He basically files a form with the county clerk or the register of deeds, and that just sits there. When he passes away, his beneficiary has 9 months in which to file what's called an acceptance of the transfer on death deed. Once that's filed, all the property listed becomes the beneficiary's property. Now there's no will, no trust, no probate, and no court. It's a pretty simple process. Often people ask, but what if there's a mortgage or a lien on the property? Is the beneficiary personally responsible for it? Well, the answer to that is no. The beneficiary does not have to pay off any mortgage or lien, but that means that the creditor could eventually foreclose on the property if they chose to. We'll show you how you can obtain an attorney-prepared form at the end of this presentation, but there's some more information you ought to know before taking this step. What if Joe makes a will either before or after the transfer on death deed? How does that affect it? Joe's beneficiary still has 9 months to file the transfer on death deed. If he does that, the property becomes his, even if Joe signs a will either before or after the transfer on death deed. What happens if the beneficiary misses a 9-month deadline? There may be several reasons why somebody doesn't file within the 9-month time period. First of all, the beneficiary might not even realize that it's necessary. Second of all, there may be a disability that prevents him from doing so. The beneficiary could also die. This could happen either before Joe, in our example, dies, or during the 9-month gap. No matter what the reason, if he doesn't file, his interest under the transfer on death deed vanishes. In that case, the property would be administered in probate, either under a will or under intestacy statutes. What if the owner signs a transfer on death deed, then later changes his or her mind? The owner certainly can sell the property. He doesn't need the beneficiary's permission whatsoever. The owner could revoke the transfer on death deed for any reason, or the owner could create a new transfer on death deed. This might be important if the beneficiary predeceases Joe. What if the owners are joint tenants? Joint tenants are usually husbands and wives who buy property together. It's called joint tenancy with right of survivorship. So what happens if there are joint tenants and one dies and the survivor changes his or her mind? Just like Joe alone, the survivor can sell the property, revoke it, or make a new transfer on death deed. In other words, the survivor can eliminate the beneficiary completely if he or she wanted to. But what if the owner creates a transfer on death deed and later gets married? In that case, once Joe dies, the beneficiary still has 9 months to file the transfer on death deed, and the property becomes his or hers. By statute, the surviving spouse has no rights to the property. What if the new spouse lives in the property and claims a homestead interest in it after Joe dies? Here's what I'm talking about. Joe does a transfer on death deed, then he gets married, and then the couple moves in together. Joe dies, and the beneficiary files a claim within 9 months. So for property that's not homestead property, meaning places where people aren't living, that would go to the beneficiary. But at this point, the law is unclear whether or not a home occupied by a spouse would go to the beneficiary or whether the spouse would be able to remain there the rest of her life. Here are some pros and cons about the transfer on death deed. The advantages are that it's pretty inexpensive to set up. It's usually pretty simple. There's no court or probate involved. The disadvantages is it fails if the property is not claimed within 9 months. It fails if the beneficiary predeceases. And if the beneficiary is on Social Security or receiving other benefits like Medicaid, receiving the property may make them ineligible for those programs. If you would like an attorney-prepared transfer on death deed, I have several packages. First of all, there's a grantor package for $69. That includes a transfer on death deed that's attorney-prepared, instructions, and copies of the statutes. The grantor and beneficiary package includes everything in the basic one, but it also has the beneficiary's acceptance forms. I think these are important because when the beneficiary needs the forms, they're at hand, so we have a less chance of missing the 9-month filing period. With both of the basic packages, the client is responsible for providing their own witnesses, notary, and filing with the county clerk. We'll certainly also be available to answer questions about the process. Let's compare a transfer on death deed to a will, trust, or an outright gift. A transfer on death deed avoids probate provided that the claim is made within 9 months. A will requires probate. Probate can be avoided also with a trust or a gift. A transfer on death deed is pretty inexpensive to set up. It's a little less expensive than a will, less expensive than a trust as well, and probably about the same price as a gift. As far as capital gains or taxes your beneficiary would have to pay if they sell the property, a transfer on death deed avoids that. So does a will and a trust. But if you give property outright, they may have some tax consequences later. With regard to the 9-month time limit, a transfer on death deed requires that the beneficiary act within that time period. The same is not true for a will, trust, or a gift. On the simplicity rating, it rates about the same as a will, trust, or a gift. If there's concerns for protecting the beneficiary, either because they're on a government program such as SSI or Medicaid, or they need some asset protection, a transfer on death deed does not provide that. A will can if it's properly set up, but a trust is probably the best route. If we want to protect the owner from the beneficiary's issues, a transfer on death, will, or trust will work, a gift won't. If there's concerns about wanting prenuptial protections, a transfer on death deed will provide some, although there's a question mark there, as wills with a trust. A gift would provide prenuptial protection. At least a gift would ensure that your beneficiary received the property. The information in this presentation is not legal advice and is based on Oklahoma's Non-Testamentary Transfer of Property Act.